Section 2, the lower federal courts. So what type of jurisdiction allows courts to hear appeals from lower courts? That would be appellate jurisdiction. Okay, our learning objectives is to explain how a grand jury differs from a petite jury. So looking at constitutional courts, the federal district courts were created by Congress as trial courts for both civil and criminal cases. In criminal cases, there are two types of juries. A grand jury, which hears charges against a person accused of a crime, and a petite jury, or trial jury, which weighs evidence presented at a trial. Now, to explain more clearly what that means, the grand jury ultimately determines if there's enough evidence for a person to really face charges. They don't actually hear the charges. They just hear evidence and determine if there's enough of it to justify the trial going forward. The petite jury, or trial jury, is where the person is actually going to either be found guilty or not guilty. In the vast majority of cases, district courts render the final decision. Many appointed officials provide services for district courts. The 13 courts of appeals ease the appellate workload of the Supreme Court. The courts of appeals may decide to uphold the original decision. They may reverse the decision, or they may send the case back to the original court to be tried again. The Court of International Trade hears cases dealing with tariffs. The legislative courts. Congress has created a series of legislative courts to help Congress exercise its powers. The legislative courts established by Congress include the U.S. Court of Federal Claims, the U.S. Tax Court, the U.S. Courts of Appeals for the Armed Forces, territorial courts, courts of the District of Columbia, the Court of Veterans' Appeals, and the Foreign Intelligence Surveillance Court. Selection of federal judges. According to the Constitution, the President has the power to appoint all federal judges with the approval of the Senate. Presidents often appoint judges from their own political party and judges who share a similar view on key issues. In selecting judges for trial courts, presidents follow the practice of senatorial courtesy, which basically means that they pretty much are going to approve whoever the president has picked. Almost all federal judges have had legal training. Many have served as state court judges. Women and minorities have been appointed as judges in federal courts in increasing numbers since the mid-1970s. Section 3, the Supreme Court. Our learning objectives for this section are to describe the jurisdiction of the Supreme Court and to explain how justices are appointed. The Supreme Court has both appellate and original jurisdiction. The court has original jurisdiction over two types of cases, those involving representatives of foreign governments and those in which a state is a party. Congress sets the number of Supreme Court justices. It has been 9 since 1869. The court consists of 8 associate justices and 1 chief justice. Congress sets the salary of the justices and may not reduce it. So in other words, this is set there. They don't want Congress to be able to punish the judges by lowering their pay, but in effect, they can withhold raises. Congress may remove a justice by impeachment for treason, bribery, or other high crimes and misdemeanors. The justices' duties are not defined in the Constitution, but have evolved from laws and through tradition, according to the needs of the nation. The justice's main duty is to hear and rule on cases. The Chief Justice also provides leadership for the court, presiding over sessions and conferences at which cases are discussed among the justices. The justices also have limited duties related to the 12 federal judicial courts, and on occasion they may serve on high-level commissions. Law clerks chosen by the justices help them research cases, summarize key issues in cases, and assist in writing drafts of the justices' opinions. Justices are appointed by the President and must be approved by the Senate. In the 20th century, most nominees were confirmed. Political considerations often play a major part in presidential appointments to the court. Members of the President's own party usually are named if the prospects of winning Senate approval are good. Now, of course, that also depends upon the makeup of the Senate. If the Senate is currently controlled by the same party as the President, then the President has greater latitude to get justices that they would like to see approved. But if the opposing party controls the Senate, they're probably going to have to find a justice that's a bit more moderate in their views. The American Bar Association, a national organization in the legal profession, has played an important role in the selection of justices by rating nominees' qualifications. Interest groups such as organized labor, civil rights groups, and the National Organization for Women attempt to influence senators voting on nominees. Sitting Supreme Court justices may have considerable influence in the selection of new justices. Now looking at Supreme Court decision-making. Chapter 12. Section 1, the Supreme Court at work. Our learning objective for this section is to explain how the Supreme Court selects, hears, and decides cases. Looking at the court's procedures. During 2-week sessions, justices hear oral arguments on cases and then meet in secret to make decisions. The justices consider arguments in cases they have heard and petitions from plaintiffs, and then write opinions for the cases that they have decided. Now, the plaintiffs are the people, of course, that are bringing a suit. Justices' written opinions interpret the law and help to shape public policy. The majority of referred court cases concerns appeals from lower courts. Most appeals concern cases in which a lower state or federal court has ruled laws unconstitutional. Cases the court chooses not to hear are dismissed, and the ruling of the lower court becomes final. Most cases reach the court by writ of certiorari, in which either side petitions that a lower court's decision involved an error, raising a serious constitutional issue. The Solicitor General is appointed by the President and represents the federal government before the Supreme Court. The Chief Justice puts worthy certiorari cases on a list for discussion. 2/3 of all certiorari cases never make the list. If 4 of 9 justices agree, the case is accepted. Some cases are decided by a brief, unsigned per curiam opinion. The rest are given the court's full consideration. Each side submits a brief detailing legal arguments, facts, and precedents. So in other words, attorneys do a lot of research, and they find other court cases that help to establish precedents. They spend a lot of time in legal libraries searching through previous court cases that they can find to make an argument that's going to support them, in addition to including the facts of the case and any other legal arguments they make. They want to back those with other decisions. Parties not directly involved with, but have an interest in the case, may submit amicus curiae briefs. Lawyers for each side make oral arguments during which justices may ask questions. On Wednesdays and Fridays, the Chief Justice presides over a secret conference in which each single case is summarized and recommendations for handling it are made. The justices spend about 30 minutes debating each case, Each justice has one vote, and a majority vote is needed to decide a case. The justices may issue 4 kinds of opinions: a unanimous opinion, which means everybody voted the same way; a majority opinion, which means a majority voted in one way or the other; a concurring opinion; or a dissenting opinion. If the Chief Justice votes with the majority, he or she assigns a justice in the majority to write the court's opinion. If not, the most senior justice with the majority assigns the justice to write the opinion. Section 2, Shaping Public Policy. Looking at our learning objectives for this section. Our learning objective is to identify ways the Supreme Court shapes public policy and to explain the limits on the court's power. Now looking at the tools for shaping public policy. The court determines policy in 3 ways. 1, using judicial review, which once again we've already established that's the way in which a court determines the constitutionality of laws. Interpreting laws. So, in other words, they're in effect determining policy by their interpretation of a law. They can also overrule or reverse its previous decisions. Using judicial review, the court may examine laws and actions at all levels of government and cancel them if they violate the Constitution. The court uses judicial review most often to review state and local cases, but sometimes its review of federal cases can have tremendous impact on the nation, as in the Brown case from 1954 and the Miranda case of 1966. The Brown case is, of course, that's the case that overturned the separate but equal doctrine, and then the Miranda case is the case which has established the Miranda rights that police read to people when they're arrested. The court's interpretation of the very general language of laws allows it to decide how the laws apply to specific situations. The court's rulings become precedents on which to base other similar decisions. However, since times change, the court may overturn or reverse its earlier decisions, as they did in the Brown case when they overturned a previous doctrine of separate but equal. Some Supreme Court decisions have resulted in great social upheaval. Limits on the Supreme Court. Generally, the court's decisions have dealt largely with civil liberties, economic issues, federal laws and regulations, due process, and suits against government officials. The court plays only a minor role in the area of foreign policy. Civil liberties cases make up the largest number of court cases. Appeals from prisoners comprise about 1/4 of its cases. By its rules and customs, the court hears only cases where its decision will make a difference, not merely those which decide a point of law. Plaintiffs must have suffered real harm, or cases must involve a federal question. The court avoids political issues. Since the court can decide only those cases that come to it from elsewhere in the legal system, events beyond the court's control shape its agenda. The court may signal its interest in a subject by taking on a specific case. The court's power to shape public policy is also limited by its own limited ability to enforce its decisions. Non-compliance by other courts is also difficult to monitor. Now, one example of this having a problem enforcing a decision was the Cherokee Nation, back in the age of Andrew Jackson, contested the Indian Removal Act. And they took it all the way to the Supreme Court, and the Supreme Court found in the favor of the Cherokee Nation. But President Jackson stated, well, now they made their decision, let's see them enforce it. And he went ahead and carried out the Indian Removal Act, even though the Supreme Court had said it was unconstitutional. Section 3, Influencing Court Decisions. Why are Supreme Court decisions so important? Our learning objectives for this section is to describe the forces that shape the Supreme Court's decisions. Basing decisions on the law. Justices must base their opinions on the law, not on personal opinions. The court must interpret laws and relate their interpretations to the Constitution itself, relevant statutes, and legal precedents. The views of the justices. Justices monitor important issues. Some become identified with them. As justices retire, the majority voting blocks on certain issues may change. In other words, generally speaking, the makeup of the court tends to be either conservative or liberal. Generally the justices are going to kind of fall into one of those basic two camps. And of course it may vary on certain issues. Some justices may be more conservative on some issues than on others. But if we talk about a voting block, there are certain types of issues that, depending upon the makeup of the court, how many conservatives versus how many liberals on a particular type of issue, that may change as different justices are appointed, and it may cause a change in the direction that the court tends to base their decisions. Now looking at relations among the justices. Modern justices meet for discussion, but they communicate mostly in writing. Personal relations among justices may influence the court's decisions. The Chief Justice's skillful leadership can help promote harmony. The court and society. Although insulated from public opinion and political pressures, the court needs public support. Its authority depends in part on public acceptance. Justices are influenced by the values and beliefs of society. Their decisions usually reflect important societal changes. So, in other words, as the overall opinion of the public changes on an issue, we can expect that the court's overall opinions will tend to reflect the general direction that society is moving towards. And of course, it's important to note that the judges themselves are a part of society, so they're influenced by these changes in society. Balancing the court's power. The power of presidents to fill vacancies in the court, as every full-term president but Carter has done, gives presidents influence over the court. As the head of the executive branch, the president is responsible for enforcing the court's decisions, but he or she may do so vigorously or with little enthusiasm. Congress has the power to limit the court's ability to hear certain cases. They may propose a constitutional amendment to overturn a decision. They may set, but not reduce, the justices' salaries, and it uses its confirmation power to shape the court's position on social issues. And now we're going to move into Chapter 15, looking at law in America, and we're going to skip ahead of skip Section 1 because we've already really covered the information in Section 1 in a previous unit. But we're going to move into Section 2, looking at civil law. Okay, and we'll start by looking at the different types of civil law. Civil law, which concerns disputes between two or more individuals or between individuals and government, makes up about 90% of the cases heard in state courts. 4 of the most important types of civil law deal with 1. Contracts, 2. Property, 3. Family relations, and 4. Civil wrongs causing physical injury or injury to property, which would be known as a tort. Contract law involves a contract or a set of enforceable voluntary promises. Property law deals with the use and ownership of property. family law deals with relationships among family members, such as marriage, divorce, or child custody. Civil wrongs or torts deal with any wrongful act for which the injured party has the right to sue for damages in a civil court. Equity law settles disputes on the grounds of fairness. Now looking at steps in a civil case. In a civil case, called a lawsuit, a plaintiff seeks damages, usually an award of money from the defendant. To begin, the plaintiff usually hires a lawyer, either on a contingency fee, which is usually about anywhere from 20 to 50% of the total award, or for an hourly fee. Now, of course, typically attorneys are very expensive when you're paying by the hour. So the contingency fee is kind of nice because you only pay if you win, but if you win, you'd be looking at ultimately losing anywhere from 20 to 50% of the total amount that you win in attorney fees. Most lawsuits go to state courts, and the plaintiff sets forth the charges against the defendant in a complaint. During discovery, each side prepares for the trial by checking facts and gathering evidence. About 90% of all civil lawsuits are settled before trial. If all else fails, the civil lawsuit goes to trial, in which procedures are similar to those in criminal trials. Civil lawsuits are either tried by a jury or by a judge who decides the verdict. When the plaintiff wins, the court awards damages. However, if the defendant refuses to pay, the plaintiff must get a court order to enforce payment. So sometimes it can be very difficult to actually get a payment, or to enforce payment, even though you've been awarded the damages. Small claims courts. Most states provide an alternative to lengthy civil trials by setting up small claims courts. Small claims courts hear civil cases dealing with collecting small debts, property damage, small business problems, and the like. Small claims court cases are usually heard by a judge and involve maximum claims of $1,000 to $5,000, depending on the state. The judge's decision is legally binding. And now we look at criminal law. The types of crime. Most crimes committed in the United States break state laws. Each state has its own penal code or written laws that spell out crimes and punishments. Crimes may be petty offenses, misdemeanors, or felonies. Petty offenses are minor, like illegal parking. Misdemeanors are more serious crimes like vandalism, and felonies are serious criminal acts like murder, robbery, or kidnapping. The prosecutor or government lawyer responsible for bringing a criminal charge must prove beyond a reasonable doubt to a judge or a jury that the defendant violated the law. Criminal cases begin when the police gather enough evidence to convince a judge to issue an arrest warrant. The arrested person is taken to a police station, the charges are recorded, and the suspect may be fingerprinted and photographed. The arrested person is brought before a judge as quickly as possible to be formally charged with a crime. If the case is a misdemeanor, the person may plead guilty or not guilty. Cases may then go to a grand jury, which determines whether there's enough evidence to put the accused person on trial, or to a preliminary hearing before a judge for the same purpose. Steps in criminal cases. At this point, about 90% of criminal cases end in a guilty plea in which the accused pleads guilty to a lesser crime in return for the government's not prosecuting the more serious original crime. And this process is known as plea bargaining. After a grand jury indictment or preliminary hearing, A judge reads the formal charge at an arraignment held in an open courtroom. The defendant may plead not guilty by reason of insanity, guilty, or no contest. In felony cases, the defendant may choose between a jury trial and a bench trial heard by a judge. Jurors listen as witnesses are called and the evidence is presented. In jury trials, the presiding judge instructs the jury on the proper legal procedures and explains the law. The jury does not go to a jury room to review the evidence and reach a decision. The jury goes to a jury room to review the evidence and reach a decision. To reach a guilty verdict, the jury must find the evidence convincing beyond a reasonable doubt. If the jury's verdict is not guilty, the defendant is released immediately. If the jury's verdict is guilty, the judge usually